that happened and once the railroad became aware of it, there was a lot of radio chatter between the railroad people, all talking to each other, trying to figure out what to do, describing what had happened. And all of their radio chatter was recorded on the computer system of the railroad company. And Union Pacific had had a number of similar type things in the past. And they have a 90-day retention system. So after 90 days, all of their recordings of voice tapes are recorded over. The plaintiff didn't file his lawsuit within the 90-day time period, filed it about a year later. And by this point, all of that railroad chatter had been recorded over, and Union Pacific said they no longer had it. So before the case came to trial, the plaintiff's attorney tried to get that. The railroad said they didn't have it anymore. So the plaintiff's attorney asked for a hearing before the judge and wanted to have an adverse inference instruction, implying so that the jury could reach the conclusion that radio conversations would have been good evidence for the plaintiff. They ended up having a 4-day evidentiary hearing in front of the judge. And at the end of the hearing, the judge listened to argument, and the plaintiffs argued that Union Pacific knew or should have known that the audio tapes would become material at some point in the future because of the severity of the injuries that had happened. Plaintiff's attorney also argued that Union Pacific had preserved tapes in the past when the information was helpful to Union Pacific. And in fact, there had been an earlier case where the tapes had been requested by the plaintiff immediately after the accident had happened. Union Pacific had destroyed them and had had an adverse inference instruction against Union Pacific during that earlier trial. So the judge listened to the arguments from both sides and at the end reached the conclusion that Union Pacific didn't intentionally destroy the audio tapes, that they were destroyed just as a result of the 90-day ongoing policy that they had. But that because they had had issues previously in the unrelated case, the court gave an adverse inference instruction anyway. The Eighth Circuit, what do you think they did? You think they affirmed the district court judge or reversed? Let's see how many think affirmed. Okay, how many reversed? About half and half. They ended up reversing. They distinguished the earlier case that had been referenced, which was Stevenson. And they said that even though the facts were somewhat similar, in that case, in Stevenson, someone on behalf of the plaintiff had called right after the accident happened and said, preserve these tapes. And in Morris, that didn't happen. No one had ever called. The other real distinguishing thing in Stevenson was that in Stevenson, they had destroyed the audio tape, but kept a bunch of evidence that was helpful to Union Pacific. In Morris, there was no evidence that they had done something similar to that. They hadn't kept anything. So the court distinguished that and found that because of those two things, there was a showing that Union Pacific had intentionally destroyed the evidence in Stevenson, but had not intentionally destroyed the evidence in Morris. They also referenced that Stevenson was really the outer bounds of when an adverse inference instruction can be given. So as you can see, every instance that the court has, it's a very fact-intensive review, and sometimes it can be the littlest things that make the difference between whether it's intentional destruction or not. But it's very important to make sure that you create a good record for the court to decide whether it was intentional or done on purpose. I'll give you another example. And this is in a case that I had not too long ago. A teacher had received a notice from the school district that she was being put put on a performance improvement plan. And she, at that point, became represented by the SDA advocate, who's not a lawyer, but it's an advocate who works on behalf of teachers. Ultimately, she received a non-renewal notice from the school district, and at that point, she had an attorney, and the school district had an attorney. They went through the non-renewal hearing. She ended up being non-renewed. The attorney at that point then sent a letter to the school district's attorney. There was a litigation hold letter. Litigation wasn't started until about 3 months after that. At some point after that, the attorney for the school teacher asked to have access to all of the electronically stored data. The school district, when they got the litigation hold letter, had told the superintendent to make sure that everything relevant was saved. The principal and the superintendent had printed off copies of emails that they thought were relevant. So by the time that the plaintiff wanted to look at the electronically stored data, the school district's 90-day automatic deletion policy had run. Everything electronically stored had been deleted and written over. They got a copy of the written emails. And the plaintiff was arguing a couple of things. One, that after the litigation hold notice had gone out, the school district hadn't done anything to preserve and save that electronically stored data. And that there would have been information in there that they believed would be material. They believed that there were communications between the principal and the superintendent about why this teacher was being terminated that would be material and helpful to them, that the school district shouldn't be able to just pick and choose what they wanted to save and only turn over the things that they thought were relevant. The plaintiff's attorney wanted to be able to get some cost shifting so that they could have their computer forensic person, the cost for them to try to recover this data saved, that they wouldn't have had to incur that expense if the litigation hold letter had gone into place properly. And they wanted an adverse inference instruction to the jury. So, with the litigation hold letter, how many of you think, because the litigation hold letter went out, that there should be cost shifting regarding the expense for the forensic examination? Those that say yes. Okay, those that say no. A couple. I ended up doing cost shifting because I thought the litigation hold letter put them on notice that they didn't take reasonable steps after that, and I cost shifted the portion that I thought was related to their failure to implement that litigation hold. So the adverse inference instruction. How many think an adverse inference instruction should be given? Couple. How many think it shouldn't be given? A little bit more. I ended up giving an adverse inference instruction. This is one of those cases where with the original hearing, I didn't think there was enough information and reserved ruling until after I heard all of the evidence during the trial and ended up through that process finding that there had been intentional destruction. But every case, they're frequently a very close call on whether you get an adverse inference instruction or not. And there's a broad range of sanctions that can be imposed. It's your obligation to make sure that the court knows as many facts as possible that are favorable to your side so that the court and the jury can make good decisions on what to do. So the last thing I wanted to talk about, you've heard everything based on the current rules, but there is a proposal right now to change Rule 37E. So everything I've said may only stay in effect for about a year or 4 months. The status of the proposed change to 37E is it was adopted 2 weeks ago by the Committee on the Rules of Civil Procedure. So it's being referred now to the Judicial Conference They meet in September of this year. And if they adopt the rule, then it goes to the U.S. Supreme Court. And if the U.S. Supreme Court adopts the rule, then it goes to Congress. And Congress has a period of time to decide whether or not to reject the rule. So the earliest it can go into effect is December of 2015. This proposed rule, the committee looked at about a year ago, a different rule. They got in a lot of comments and made very substantial changes to the proposed rule. So the one that they adopted is very different than the one that they looked at a year ago. But this has now been adopted and passed by the committee. And it's the one area where this rule would apply only to electronically stored information. So it would carve out a separate rule dealing with ESI. Right now, everything that we deal with just falls under the general rules of procedure. So this would carve out its own separate rule dealing with ESI. And under the proposed change, first of all, we would look at whether the information should have been preserved in anticipation or conduct of litigation. And if it in fact was lost, the court would have to also look at, could it be restored or replaced through additional discovery, and whether the party took a reasonable step to preserve it. If those findings are made, then the court has to look at whether there's prejudice to the party, and it could order relief no greater than necessary to cure the prejudice. So it's a much smaller toolkit that the court would have on what relief could be carved out. The next part of the rule indicates that if there is a finding of intent to deprive the other party of the information, then the court may presume that the lost information was unfavorable to that party. It may instruct the jury that it may or must presume the information was unfavorable, or it may dismiss the action or enter a default judgment. And as I said, this rule applies to ESI only, and it's one of the first times I've seen that they've carved out a separate rule dealing with just ESI. So in making some of those determinations in the notes to the proposed rule, the court has said that, or the advisory committee has said that the court can consider things like the party's resources and try to make sure that the relief that's given is proportional to the efforts to preserve. The court should look at the party's sophistication regarding litigation. A big issue is if reasonable steps are not taken and the information is lost, is there another way that it can be restored or replaced? And if it can't be restored or replaced, is there prejudice? If there's prejudice, then the court can order relief to cure that prejudice, but nothing greater than that. If there's an intent to deprive that's shown, the court would instruct the jury that it may or must presume the information was unfavorable to the party or dismiss the action or enter a default judgment. And that's it.
Good morning, everyone. Our last speaker today is the Honorable Craig Fikely. He's a judge out of the 7th Circuit in South Dakota. He's here today to give us the perspective of what's happening in state court here in South Dakota. He received his law degree from the University of South Dakota and then clerked for Justice Robert Morgan with the South Dakota Supreme Court. He was then in private practice for several years, working in civil litigation in state and federal court. And then in 2011, he was appointed by Governor Dugard and took the bench in January of 2012. So Judge, we're ready to hear from you.
Thank you, Mayor. Good morning, everyone. I did not prepare a PowerPoint because if I did, the only slide that would have been needed was the one that Bob Colleen had at the state of South Dakota that said unknown. I can guarantee you at the end of my discussion, the status of electronic discovery in South Dakota will remain unknown. Generally speaking, state court judges who are looking at issues concerning electronic discovery in the state of South Dakota have a couple of different avenues available to them in terms of how to address the questions you are bringing before us. We have a couple of different discovery rules that encompass all general discovery disputes that are brought before the court. Those allow us as state court judges to take an opportunity to look at issues that concern timing, issues that concern costliness of the discovery, and issues that concern the nature and terms upon which discovery may be ordered. You've heard some reference by our prior speakers to the federal rules in terms of cost shifting analysis and some other things. The general South Dakota rules, in my perspective, offer that opportunity for you to address those issues when you bring ESI disputed matters before a state trial court judge. I think the key that you need to remember when you're doing discovery in state court and have a dispute concerning electronically stored information is to remember to educate the judge about the nature of that dispute as early as you possibly can. The South Dakota rules allow you the opportunity to put in place a discovery plan. I would urge you early on in any case that you can, in which you have some understanding that electronically stored information issue may be possible, to meet and confer with opposing counsel so you have the opportunity to place that plan in place and get some materials available for the judge to have access to in the event that dispute surrounding that plan arises. Let me make a couple of comments on that, and sort of what I'm talking about, the sort of things that I look at in those circumstances in which we have disputes concerning ESI. For example, we heard some discussion this morning about the format in which materials may be requested. We've heard the terms native and non-native production. I'm not going to suggest to you that I have the capability to comment on what that all means, other than to advise that planning early in terms of your discovery disputes, your discovery plan, I should say, to avoid disputes, and the nature of that particular format of discovery is important to the court. Here's why. In my experience and my understanding, if production is requested in native format, there can be requirements that are more technologically difficult or require more technological expertise to produce that material. In certain circumstances, when a state court judge looks at issues concerning discovery disputes and looks at the avenues that I have available in resolving that particular issue, for example, whether or not the requested discovery may be burdensome and oppressive, one should take into consideration the nature and extent of the dispute at issue. If you are asking for a significant amount of technological work to be done to produce native format information, for example, in a case in which the disputed value of the case altogether is limited, it certainly makes sense from a state court judge's perspective to limit your access to certain types of materials or certain formats of material in light of the nature of the litigation altogether. So keep those sorts of things in mind, and those are some of the things that would be important for you to bring to the judge in a state court action in which you have a dispute concerning the manner in which, or the format in which discovery is produced. I also ask you to consider time constraints when you're looking at these particular issues, because obviously certain types of discovery of electronically stored information can be more timely in terms of either being able to be produced quickly or perhaps requiring some technological and technology-related assistance or software review that would require the judge to have some urgency in trying to get the matter resolved, those sorts of things in mind. Essentially, what I would like to urge upon you when you're considering production of materials and disputes of electronically stored information discovery in state court is the suggestion that a discovery plan placed before the judge at a very early stage of the proceedings is critical not only to efficiency and orderly preparation of the case, but allowing the judge and assisting the judge in making sure that he or she has a better understanding of exactly what you were looking for and exactly what the dispute is in terms of how we need to move this forward. I would ask that you take the opportunity to perhaps put forth a discovery plan. That plan, under our rules, has the capability to be executed by the judge as part of the trial ruling. So take the opportunity, if you know you're going to have those types of issues in your particular case, to put matters together and present that to the judge. That also is an opportunity to look at issues that have been discussed here this morning in terms of the manner in which the materials are produced, the format in which those materials can be produced, perhaps cost shifting issues as to who's going to bear the cost of production on those particular issues, and all those can be addressed rather easily in a pretrial discovery order. There are a number of different options available for you to do that. There are a multitude of research and examples that are available online for your use in putting that together for purposes of the judge. But keeping in mind that there are no specific rules in the state of South Dakota that relate to disputes concerning ESI, it makes some sense for you to take the opportunity to educate your judge at the earliest possible moment, with a plan in place for that judge to be able to work with and address as issues come up. A couple of other things that I think are important to address as it relates to ESI and discovery issues in South Dakota. We've had some discussion today about corollary issues that are necessarily about the discovery or discovery disputes themselves, but relate to issues concerning privilege, which relate to issues concerning spoliation. Those issues aren't unique to the federal court system. They also arise in state court proceedings as well. A couple of different comments. Those issues can and should, if at all possible, be addressed in your pretrial discovery orders if you have that opportunity. For example, the federal rules in 502 have some inadvertent release of information or privileged information clawback provisions that allow you some protection in the event that in producing volumes of ESI, for example, you have material that was inadvertently sent out. South Dakota doesn't have that corollary to its version of 502, so that perhaps can be addressed in any pretrial discovery order. The second thing that you need to look at is that spoliation question. South Dakota, as Judge Schreier mentioned, has a specific pattern instruction of negative inference instruction that can be given by the trial court, assuming that bad faith is proven. I remind you that a couple of different things